Justice Gorsuch?
Well, you're not going to like this anymore. Just to follow up on Justice Kagan's thought, I wonder whether we're essentially asked to, between these two choices, I just wonder if you think this is a fair summary of our choices in defining what constitutes categorically obstruction of justice. One option would be to look to the common law and to this Court's decisions in Pettibone and Aguilar and say, well, that usually meant, at common law, traditionally, that there was an ongoing proceeding. Obstruction of justice was contempt of court, things like that. The other is to look at dictionaries and say, well, there's some linguistic drift in this concept. And when we speak casually, the gist of any kind of thing that impedes an investigation, failure to report a crime, accessory after the fact, witness tampering, they sound sort of like obstruction of justice, and they would fall within a contemporary dictionary definition. So that should be the choice we make. Is that a fair summary of our two choices here?
Well, I would quibble with both halves briefly to say that with respect to the first part, Pettibone and Aguilar were not talking about the common law. They were talking about a specific statute.
I understand that. But if we look at the common law, it's consistent with Pettibone and Aguilar. I think we'd find. So I take your quibble.
And
but
with respect to the second half, I would say that we're not just resting on dictionaries. We're resting on a lot of other federal and state criminal offenses. We think that 1512 is an obstruction of justice offense. We think Section 3 is an obstruction of justice offense.
Let's take 1512. I mean, that may be your best one, and you rely on it a lot in your brief, and that has to do with witness tampering, of course. But Congress there specifically said, in this instance, you don't need to have a pending proceeding. And I take the point that in some ways might seem to help you, but might it also hurt you in another way, in the sense that their Congress exhibited an understanding that normally obstruction of justice, as understood in common law, the soil that came with 1503, requires an ongoing offense, but not in this case, Congress said. So isn't it the exception that proves the rule?
We don't think it is, because we think that Congress was clearly distinguishing the new provision from 1503, but that doesn't mean that Congress didn't think that 1512 was also an obstruction of justice offense. And indeed, it was understood that it was going to take on a lot of the cases that had previously proceeded under 1503.
And then in this linguistic drift concept of obstruction of justice as from the dictionary definitions is impeding a process of justice, I think is how you use. Well, what does that mean? Is that defined in law anywhere?
There's not a separate definition of that, but we do think that you can impede.
I'm not aware of one, and I didn't see one in your brief.
I mean, I think that the ordinary meaning of the phrase impede or interfere is to prevent from being effectuated in its full way, and we think that you can impede an investigation by keeping it from getting off the ground.
Thank you.